Okay. Good morning, ma'am. Am I audible?
Yes, sir, absolutely. Yes.
Yes, you are audible. Yes, you are audible.
Okay. Okay. Good morning to all. On behalf of the Institution's Innovation Council of MCKVIE Institute of Engineering, Howrah, West Bengal, I would like to welcome you all to the first session of MIC AICTE sponsored Impact Lecture Sessions. Actually, the objective of the Impact Lecture Series scheme is to promote and create awareness on innovation, startup, and intellectual properties among the students, faculty members, and staff members of IIC institutes. Through this Impact Lecture Series, selected IICs has been permitted to organize 2 lecture series in the field of innovation, startup, and intellectual
definitely the resource scarcity are going to be there. Managing today, there are different types. There are a lot of, if I give you the example of, the Godrej type of business, there are a lot of, family, Reliance business, it's a family run business, right? How it's managed, what are the clear job responsibilities, what is the hiring criteria, how to, what is the commitment? Because whenever there's a family business, the chances are that, the conflicts will be higher. How Reliance manages that, right? Because there's a clear-cut distinction between what his elder son of Mukesh Ambani will be handling, what his daughter will be handling. So there are watertight compartments of each and every segregation of the job so that the conflict is lesser. Very important, like the question is that when we talk of the entrepreneur, entrepreneurs have to think ahead of time, otherwise they cannot move successfully as an entrepreneur. But having said so, entrepreneur today is also no less important. The biggest example is Sundar Pichai of Google, right? He's not a co-founder of Google, but he's the person, he's the name behind the success of Google today. So yes, how the leader within the organization in the name of entrepreneurship bring it to that level. Even in that context, I can give you the example of Indra Nooyi of PepsiCo also. So it's very important how to get it going. And entrepreneur, as again, I'd like to say that, entrepreneurs have the mindset to create, right? They are very visionary. They think ahead of time, but the risk is also there. But the question is that how do they mitigate the risk using the strategy? That's all from my end. I think so. We are on time. It's 3 o'clock. So thank you very much. And so over to you guys. Hello.
Yes, hello.
Yes.
Thank you, ma'am. Thank you, ma'am, for your very wonderful and innovative lecture that we enjoyed for the last 1.5 hours. So any questions from the audience, please? Are we expecting any questions from the audience? If not, then thank you, ma'am, once again. I think we come to the end of this lecture session. Thank you so much for being with us and spending your valuable time with us. Thank you, ma'am.
Thank you very much.
Thank you. So the next lecture session.
Ma'am. Puvali madam.
Yes, sir. Yes, sir. Please.
Please wait for a minute. As per the AICTE norms, we need to take a group photograph with our expert, and while keeping the video mode on for all the participants. And so,
Okay.
so can we request all the participants to keep their video modes on so that we can take a group photograph? And please request Sumit sir to take the photograph. Sumit sir, please take the photograph. Madam, is it done?
Yeah, my part is done.
No, I am asking Jayanti madam. Ma'am. Jayanti madam.
Yes, sir, it is done.
Okay, thank you. Okay, thank you, Professor Goswami.
Thank you.
Thank you. We will be in touch.
Okay,
Thank
sure.
Puvali madam, you may continue.
Okay, thank you, sir. So we come to the next part of our session for lecture session 2, which is the role of intellectual property rights in innovation. And our eminent speaker is Mr. Santanu Dey. Mr. Dey, a Bachelor of Mechanical Engineering and holding post-graduation in management, is working as Deputy Controller of Patent and Designs and NIPAM team leader under the Ministry of Commerce and Industry, Government of India. On behalf of the organizing committee, may I request Mr. Dey to please share his knowledge with us. Please, sir.
Okay, good afternoon, madam. My name is 𝑠𝑜𝑐𝑖𝑎𝑙𝑠. I am the coordinator from IPO Kolkata end, and with me we have our respected Deputy Controller, Mr. Santanu Dey sir, and we are very happy that MCKVIE is contacting with us and give us an opportunity to give a lecture on intellectual property rights. And we all know that nation is celebrating the 75th anniversary of its independence, and on this occasion, with the collaboration of AICTE, our office IPO Kolkata under the Ministry of Commerce is conducting so, and we are very fortunate that MCKVIE has given us an opportunity to conduct this program. In this occasion, I want to thank Dr. Prasenjit Chatterjee, President of IC, and Dr. Devapoma Ray, the coordinator of this program from MCKVIE. I think you all are, my voice is clear, and you all are visible with us. Can anyone please confirm with you?
Yes, sir. Your voice is clear.
Okay. And the slide is visible. Our slide is visible.
No, sir. Jayanti ma'am, can you please off our flyer so that they can share the slide?
Is our slide is visible?
Yes, sir. It is clearly visible.
It is clearly visible. Okay. So can we start the program?
Yes, sure.
Yes. Okay, sir. Santanu sir, please.
Thank you, Mr. Abhishek, and it's a great pleasure for me for attending such a program, and it is organized by MCKVIE under AICTE program. And am I audible now? Am I audible? Please, anybody can respond. So whether am I audible?
Yes, sir.
Okay.
Yes, sir, you are.
Okay. I request everybody, please mute yourself during the session, and after the session there will be an interactive session, and during the session please mute yourself. So let me introduce first. I am Santanu Dey, Deputy Controller Patents and Design from Patent Office Calcutta. I am working in the Mechanical Engineering Division, and I'm going to start. Our topic is role for IPR in innovations. And in that occasion, I must say about the National Intellectual Property Awareness Mission, which is developed and under the occasion of Azadi Ka Amrit Mahotsav. And in that occasion, I am telling about the role of IPR in innovations. First of all, in case of IPR, what do you mean by IPR, I should say, and what is the role of IPR in case of innovations? And the IPR word, that is intellectual property right, the combination of the three words, intellectual property right. That means that intellect comes from our brain and that should be protected. Otherwise, it may be copied. And IPR, that is the intellectual property right, the different subject matter and different subject matter can be protected under the different chapters. And I am telling about the different intellectual property rights. Different intellectual property rights. First is patents, then design, then trademarks, geographical indications, copyright, and semiconductor integrated circuit layout designs. There are the different chapters. Patents for innovation, that is, any invention can be protected. Otherwise, it is copied by another person. And design. Design, what is design? Design can be protected by the shape and configurations of any object. And then trademark. Trademark is nothing but a symbol and a mark that can be registered for the reputation of the company or for the reputation of the product. And then geographical indications. What is geographical indications? That is a product that can be attributed for the particular geographical region, and that can be protected under GI. And copyright. Copyright is literally an artistic work that can be protected under copyright. And then the next chapter is SICLD, that is Semiconductor Integrated Circuit Layout Design, that cannot be protected under patent, and that can be protected under another chapter, which is called Semiconductor Integrated Circuit Layout Design. Now I am showing the picture by which the different IP, that is intellectual property, can be protected in a single drawing. That is, there is a LED display of the laptop that can be protected under patent because it is a inventions. And the body of the laptop, that is a specific configuration and specific shape of the laptop, that can be protected under design registrations. And there is a sign, that is the Apple sign, that can be protected under trademark. And user manual, that is how to operate the laptop, that is protected under the copyright. And there is a layout inside the laptop which can be protected under the SICLD. Now already told, that is the intellect that comes from the brain, and by the help of resource and labor, the combination of resource, brain and labor, that property is intellectual property. That is an intangible property. That is not tangible property like our house and car, etc. That is intangible property, and that can be protected, otherwise it is copied. Importance and significance. We should protect, we should exclude others, and we utilize the commercial earning. That is why we protect, because to exclude others. And as a result, we always earn some commercial gain. And utilization and commercializations are the different purpose. It can be used for own use, it can be licensed, it can be franchised, it can be merchandised. Now, there are the two persons mainly in the art, that is common persons and business persons. And the perspective of protecting the IPR for common persons and business persons are different. For common person, it is pride and academics. And for business persons, it is to be utilized, it is to be commercialized for the brand value and to earn and invest. Now the next chapter is It is the first chapter of IPR, intellectual property right. It is patents. A patent is a statutory right for an invention granted for a limited period of time to the patentee by the government in exchange of full disclosure of his invention for excluding others from making, using, selling, importing the patented product or process. Legal right to exclude others from using your inventions, and no concept of the global patenting, and tenure of the patent is 20 years from the date of filing of the applications. So there are the no concept of the global patent. That means if you are applying in India, that patent is confined to the geographical region of India only, and it is not applicable to USA or any other country. And the tenure is, that is from the date of filing, it is 20 years. And who is granting the patent right? That is the government of India. And who is getting the patent? Who is applying for the patent? That is maybe the applicant and maybe the inventor. Inventor, if wants to assign its right to applicant, then applicant can get the patent right. And how to exclude? Excludes others from making, using, selling, importing the patented product or process. And in this respect, I must tell about that is complete disclosure should be furnished in terms of the complete specification. Otherwise, our section, that is section 10, prohibits that the patent will not be granted. So, at the time of the drafting of the patent, we should concentrate in such a way that the complete disclosure will be furnished. For that reason, it is mentioned that in exchange of full disclosure of his inventions. So, for drafting of patent, we should concentrate and we should very much careful about the full disclosure of the specifications. Now there is a video, you can see the video. Now there are some famous inventors and inventions. In 1856, George Alfred Deepening, civil engineer of Calcutta, petitioned the government of India for grant of exclusive privilege for his invention, an efficient pankha pulling machine. Why it is so famous? Because it is the first patent in India. And there are some scientists and there are some inventions. That is the Alexander Graham Bell for telephone, Wright brothers for airplane, etc. Here you can see the small invention, but that can be protected under the patent, and the patent publication number is W2011044642A1. It is a small invention, why I'm telling, and is very useful invention for the cricket games. As whenever it is the LEDs, whenever the stump is broken, that cannot be identified by the umpire. So if there is a LED or there is a little display, whenever it is broken, that can be easily identified by the umpire. So it is a small invention and that can be protected under the patent right. You can see some famous inventions, that is nano car, which is very much cheap, hepatitis vaccines, Jaipur food, everything is very much cheap. You can see some drawings which can be protected under the patent. There is a device which can protect the head of the child. There is a display above the hand of the mobile that is also protected under the patent rights, and there is a device by which the debit card or credit card can be functional. There is a drone. So all these are not the patent subject matter. Patent application filing, how to file the patent application. There are some forms, that is Form 1, Form 2, Form 3, Form 5, and Form 18. What is Form 1? That is the detail of applications, applicants. And here for Form 1, fees need to be paid. There is a Form 2. Form 2 is the details of the inventions, where the complete specification can be disclosed. And then the Form 3, details of foreign filing particulars. Form 5, that is details of declaration as to inventorships. And Form 18, that is a request for examinations, and which can be filed within 48 months from the earliest priority or date of filing, whichever is earlier. Otherwise, the application is deemed as withdrawn. For this case, that is the Form 1 and Form 18 are fees is required. For Form 2, fees is not required if the specification page restricted to 30 pages and 10 claims. Otherwise, for more than 30 pages and more than 10 claims, extra fees will be paid. Now I'm telling about the fees. That is Form 1, 1600 for natural persons other than natural persons, that is company, 8,000. Form 2, I already told that for 30 pages there is no extra fees, and for 10 claims also no extra fees, but more than that you have to pay for extra fees. Form 3, no fees. Form 5, no fees. Form 18, that is 4,000, and for company it is 20,000. So for natural person, the total patent application filing fee is 5600, and for company it is 28,000. Filing procedure, you can file through online or offline. For online filing, there is an online portal. You have to create the user ID and password. Then you have to upload the complete specification and different forms in PDF form. And then you should have a digital signature, and then you have to pay for the fees. There is a comprehensive e-filing portal. There is a login you have to create, and there is a payment gateway. You have to provide the fees. Now it is an expedited examination. What is expedited examination? Expedited examination is a separate queue from the normal examination procedure for making the examination process more faster. And who are eligible for the expedited examination? That is startups, small entity, applicant is a female, departments of the government, or other government establishment. India has the IIC and IPA in PCT, and agreement between India Patent Office and Foreign Patent Office. So here it is mentioned that IIC and IPA. What is IIC and IPA? IIC means International Search Authority. Whenever the international application is filed before WIPO, and for that international application, if the International Search Authority is selected as India, then they are eligible for the expedited examination. Patent application processing. Patent applications, that is PCT, convention, and ordinary application. For ordinary application, there is a provisional specification, and for provisional specification, you have to file the complete specification within 12 months, or otherwise it is treated as abandoned. And then it is published under section 11A, and then after publication and request for examinations, your application will be examined and the first examination report will be issued. And after the first examination report, you have to comply with all objection within 6 months, extendable by 3 months. And then subsequent examination report if required, or otherwise you are offered for the hearing and disposal by the grant or refusal. Now I'm telling about the screening and classification. What is screening and classification? Why it is required? Because the screening is required for the invention is for different fields, and we have to screen with the different invention into the different examiners. And there are, in patent office, there are 4 divisions. 4 divisions mean one is chemical, number 2 is biotechnology, number 3 electrical electronics, and number 4 is mechanical, civil, etc. So as per the screening of the invention, it will be screened and it will be allotted to the different field of examiners. And another thing, or another purpose of the screening is to classify as the whether it is the atomic energy or whether it attracts the defense purpose. If it attracts the atomic energy, then permission for DAE it is required, and if it attracts the defense purpose, then the Ministry of Defense clearance is required. Now examination is classified into 2, that is formal examination and technical examinations. And then the first examination report, and then the examination of the reply of applicant, then hearing, and then the grant or refusal. Technical examination. How the technical examination can be done by the examiners? That they read and understand the invention in relation with the drawing, search for related earlier publications, citations on the worldwide database, check for novelty and inventive step with respect to the citation, and prepare the detailed examination report. So, for examiners, he or she has to read the and also understand the inventions. Then he or she searched for the related or earlier publication or citations, and it is searched globally, and then the novelty and inventive step can be established. And after the establishment of the novelty and inventive step, the examination report is prepared and it is approved by the controller and it is issued to the applicant. Basic timeline, that is provisional specification 12 months, request for examination within 48 months, reply to FAR within 6 months, extendable by 3 months, form 5 within 1 month, withdrawal of application, that is 15 months, hearing submission within 15 days, and pre-grant oppositions before the grant and post-grant opposition within the 1 year from the date of grant. And here is a procedure. Here it is written that withdrawal of application, that is withdrawal also possible for the publication, that is 18 months, and it can be done within 15 months. Now the next topic is design, and I already told about the design, that is the shape and configuration of any product that can be registered on the separate chapter which is called the design. There are some Design Act 2000, Design Rule 2001, and Design Rule 021 related. And the term of the design is 10 years, extendable up to 15 years. Design means only the feature of shape, configuration, pattern, ornaments, or compositions of lines or colors applied to any article, whether in 2 dimension or 3 dimension or in both, by any industrial process or means, whether the manual, mechanical, or chemical, separate or combined, which is separate combined, which is finished article appealed to or judged solely by the art. That means we are judging the design applications, only the configuration, only the shape, only the color, and technical aspect is not determined in case of design protection. It is unlike to patent application. Now there are some definitions, article under section 2A, whether it is original or not, section 2G. And here you can see some design articles, that is a sofa and watch, and for every product, it is protected for the shape and configuration. Now the set of articles, that is a set, crockery set, that can be protected. That is a sofa cum bed. That is the filing of design application. You can see the flow chart of the filing of the design applications. It can be filed electronically, it can be filed also physically. For physically, it can be IPO Delhi, IPO Mumbai, IPO Chennai, and IPO Kolkata. For physical application, it is digitized and then it will be processed. And for physical filing, DD in favor of controller design, payable at Kolkata. Now, for requirement to file for ordinary application, the application fees is 1,000 for individual and 4,000 for the company. Application is Form 1 and 2 sets of representation illustrating the various views of the articles, power of attorney if required, and the assignment document, it is also if required, and form 24, that is the applicant is small entity or startup to get the fees discount. Here you can see the design registration certificate. Here you can see the design publication journal. And showing your IP is protected. Before delivery or sale of any article to which registered design is applied, each article to be marked with registers or REGD or RT, and also with registration number, except for the textile goods and the brittle article. This may deter the potential infringer and help in legal action. Important timeline for ordinary applications. The reply to FER should be filed within 6 months, and 6 months can be extendable by 3 months, and term of the design also 10 years, extendable up to 5 years, and request for renewal to be filed within 10 years, and request for restoration of the lapsed patent to be filed within 1 year from the date of cessations. Now the next chapter is trademark, and trademark is why it is important, because it is a mark that can be registered for a product, and for the quality of the product that can be registered for the trademark. And there is a difference between the trademark product and non-trademark product, because most of the customers assures that the quality can be assured by the trademark product, and for that reason the trademark is registered by identifies the source of origin and goods and services, and assures the customers about the quality of goods and services. Here you can see some symbols, that is Google, Adidas, McDonald's, etc. Now, what is good trademark? Good trademark should be distinctive, that's inherent or acquired, and not deceptively similar. Not deceptively similar means it should not be misleading. Should not be misleading, because in a particular field for a particular products and services, if it is already registered by the famous trademark, and in the similar field or product and services, similar trademark, that is not the same trademark, but the similar trademark is registered intentionally, then that intention is not good and it is misleading to the customers. So that misleading or deceptively similar trademark should be rejected. For instance, I can cite one example of the Armenia and New Armenia. So New Armenia is the deceptively similar trademark. Now, how to indicate your trademark? If it is not registered, that is unregistered, application is pending, then it can be defined by TM, and when it is registered, that can be identified by R. How to protect the trademark? Trademark registration is optional. However, the registration has certain advantages. Registration available at the national, regional, and international level. Initially registered for 10 years, can be further renewed indefinitely, 10 years for each time. In case of non-use, non-renewal, or no policy, trademark rights are lost. Now the next chapter is copyright. Copyright is a right given by the law to creators for literary and dramatic, musical and artistic work, and producer of cinematic films and sound recording. It is a bundle of rights including the right of reproduction, communication to the public, adaptation and translation of the work. Copyright does not ordinarily protect titles by themselves or names, short word combinations, slogan, short phrases, methods, plots, or factual informations. Copyright lasts for 60 years. Originally, the literary, dramatic, and musical or artistic work, the 60-year period is counted from the year of following from the date of the author. Cinematographic film, sound recording, photographs, etc. Works of the government and works of the international organization, the 60 years period is counted from the date of publications. The term of protection, it is the section 22, that is published literary dramatic work, that is life of the author plus 60 years. Cinematographic film. Cinematographic film and sound recording, 60 years from the date of publication. Broadcasting and reproduction right, that is 25 years from the year of following of the year of the broadcasting. And performance right, that is 50 years from the year of following of the year which performance is made. Now there are some features of the Copyright Act 1957. There are provision related to the Copyright Office. It is under chapter 2 and 10. Provisions for the statutory and compulsory licensing of work, chapter 6. Provision related to the right of the owner of the copyright and the tenure of protection, that is chapter 4. Provision related to broadcasting, that is chapter 8. Provision related to infringement and remedies, that is chapter 11. There are some literary works under section 2.0, artistic work, that is section 2C, dramatic work, that is section 2H, musical work, section 2P, sound recording, that is section 2XX, and section 2F cinematographic film. So there are different sections for different protections of the copyright. And who are the author of the work? That is the literary or dramatic work, that is author. Musical work, that is music composer. Artistic work, that artist. Photograph, that is the person who is taking the photograph. Cinematographic work, that is the producers. And literary dramatic work, the person who causes the work to be created. Now the copyright, the right is classified into two, that is economic right and moral right. Economic right is a transferable right that may be assigned to any other persons, and moral right that cannot be transferred. Because if one cinematographic work is being done by the producers and then he wants to distort the story of the author, then the moral right belongs to the author only, and he has to get the permission from the author. And after that only, he can implement the story, distorted story. It is called the moral right. Scope of economic right, that is the reproduction right, preventing others from making copies. Distribution right, the dissemination of the physical copies of work. Right to create derivative work, adaptations, and right to communication to public, relaying of work. Right to public performance, right to perform the work in public. Right against the distortion, what I already told, and right of recognitions of the authorship. Right of recognition means that is the author and the cinematographic work. That is the cinematographic work, when it is done by the producers, he has to recognize the contribution of the author for the cinema. It is called right for recognitions. Application procedure, it is under Form 14. Every such application can be filed in the Copyright Office, which is located in Delhi, by post or by e-filing facility. And what are the fees for literary work? 500 rupees, artistic work 2000 rupees, sound recording 2000 rupees, and cinematographic work, that is 5000 rupees. Next chapter is SICLD, that is the semiconductor integrated circuit layout design. This integrated circuit is present in televisions, in laptops, and that cannot be protected under the patent, and it is a separate chapter is SICLD. Semiconductor integrated circuit means a product having the transistors and other circuitry element inseparably formed or inside a semiconductor or insulating material designed to perform an electronic circuitry functions. The layout design means the layout of transistors and other circuitry element and includes the lead wire connecting such elements and expressed in SIC, Semiconductor Integrated Circuit Layout Design Registry. It is located in Delhi, and SIC is an important IPR for protection of the product with fast changing technologies such as electronic gadgets and computers. Registration of layout design is for 10 years from the date of application filing or fast commercial exploitation, whichever is earlier. There is a typical flowchart, the filing of applications, and then it is registered, then it is published, and it is accepted. And if there is an opposition can be heard and it is disposed. Now the next chapter is geographical indications. Geographically, you can see one video. So you can see the video, and there are different GI products. You can see Darjeeling tea, Nilgiri tea, and different products are there, and different services are there. Service can also register, and product can be registered for the particular attribution of the geographic locations. And for that reason, it is called the geographical indication. You can see Darjeeling tea, Makrana marble, Kanchipuram silk, etc. You can see the Katputlis of Rajasthan, that is the service. And different products, that is Maghai Pan, and mango is also registered. And IP everywhere, you can see the video. Now, there are the validity of different IPRs. For patent is 20 years, design 10 years, extendable by 5 years, trademark indefinitely subjected to renewal initially for 10 years, GI subjected to renewal initially for 10 years, and copyright is also it is already mentioned. And who can apply for the different IPRs? Any person can apply for IPRs except for GI. Person cannot apply for any organization, any NGO, or any firm that can apply for the GI. And all IPRs are territorial in nature. That means it is restricted to the specific country only. Points to remember: that is first to protect and then publish. Rights are territorial in nature. Registration is done by the sovereign authority, that is Government of India. Rights for limited period of time and no automatic relief. Needs to file the infringement suit. Renewal files to be paid for some IPRs, and appointment of patent attorney is not compulsory. Now, the next chapter is career opportunity. It can be applied for the government job and it can be applied for the private job also. For government job, you can directly recruited as examiner of patents and design, examiner of trademarks and GI, and examiner of copyrights. And for private job, you can act for patent attorney, trademark agent, JRF, SRF in patent facilitation centers, and patent litigations and other opportunities in the private sector. Now that the contact details for further training, if you want to be further trained, then you can register in our training institute, which is located in Nagpur, and it is called Rajiv Gandhi National Institute of Intellectual Property Management, RGNIIPM. And you can contact over the phone or over the mail ID. So I am concluding my sessions. Now you can unmute yourself and you can ask any questions.
Sir, can you please share the address once more?
Share the address.
Yes, the address is here. Can you see the slide?
Thank you, sir. Thank you.
Okay. I request everybody to switch on your video so that I will take a screenshot for our reference.
We have to take the screenshot. Please make the video on.
Okay. Thank you. If anybody have any question, you can ask.
Ask me, unmute yourself, and if any question is there, please ask.
Is there any question from the audience, please?
If you have any question, please ask.
Okay. Then we are concluding our session. Should we conclude our session?
Yes, sir. You may if you feel so.
If anybody have any question, then actually we have done
Yes,
our part.
definitely. Is there any questions from the audience?
Okay, ma'am. Thank you, ma'am, for your valuable time and joining this program. And
Yes, thank you, sir. On behalf of the organizing committee, I would like to thank Mr. Dey and you too for being with us and spending your valuable time sharing your immense knowledge and information with us. So with that, we come to the end of today's program, and I would also like to convey my thanks in regards to all the participants present here in the online mode. Thank you so much. Thank you.
Thank you. Thank you very much.